be possible? Will it be possible for you to please take a photo of all the participants?
Hi, Matilda. Should I do a screenshot now, or are the participants going to first show their faces and the camera on?
Yeah, no. Kagisho, thanks for that. Will everybody just switch on their cameras for a few seconds, that we can just take a nice screenshot? All of you who can put on your faces, please put it on that we can see all of you.
Matilda, can I please interrupt there? I see
Yes,
there are
Arno?
still people connecting. Can we perhaps wait a little bit so that everybody can be on before we take the photo?
Okay. Do you think, should I
I've
start
seen there
with
was
the,
somebody connecting.
Arno, do you think we should start with the meeting and then say in 10 minutes time, I make a note here and then we take the photo?
I think that will be best so that we can have at least some people on our photo.
Kagisho, will you be available in 10 minutes time?
Yes, I will.
Okay, thank you so much. I hereby would like to welcome each and everybody who is on the meeting at this moment. We really appreciate your time and effort to join us, and we are very much looking forward to this, to our theme of the day, Carita. We really hope you can give us some good information and nice tips that we know how to handle this new act that came into place. Thank you very much for your time, and we'll introduce you a little bit later. Is there anybody with apologies for today? Rhonda did apologize because of internet problems, but I see she is on. We are glad that you are here, Rhonda. The next point on the agenda is then personalia. Is there anyone who would like to comment on the personalia who have graduated, whose children have passed matric and got some good results? I'm thinking about Esma. I know her son did very well with his matric results. Is there anyone else who would like just to share something personal with us? People, you can speak to me. I don't want to be listening to myself the whole time and no one is commenting.
Very healthy group that's listening to you. There's no personalia, it seems.
Yeah, it seems to me I'll be the only one speaking today. Okay, then we move on to minutes of the meeting of 10 June 2021. It was circulated together with the invitation. So is there any comments or corrections that we need to do?
Matilda, can I just interrupt again just before we move on there? Setting of the agenda point 4.
Sorry.
And there I want to add something because I omitted in the agenda. I didn't put a place there for the speaker. Sorry to our speaker, but it was omitted. So after the matters of the day, there should be a speaker. So it should be point 7 should be speaker, point 8 next meeting, point 9 closure.
The invitation that you sent to me does look like that.
Okay, so perhaps it's another version that I sent to you because the one in front of me, there's no speaker.
Okay, no. We have, and we won't forget about this. So, yeah. I just want to find out, can everybody just switch on the cameras now? Because I believe most people have joined. So please switch on your cameras, and Kagisho, will you then please take a photo for us?
You must say when we must smile.
Kagisho, are you there?
Yes, I'm still here. I can see
Okay.
there's two people who are still trying to connect. I'm just
Well,
going
are
to
they
give them a
still
few.
people?
Yes, but
Okay.
for now, I've already taken the picture. Let me just wait for the last two to connect, then I will take a second picture.
Okay, because I only see 4 people on the screen. Where's the rest? Please switch on your...
on the screen.
We are here. We are here.
No, there's a few photos.
Well, okay. That's
So Carita, this is for you.
Okay, let me just quickly take the last one. And there we are.
Thank you, Kagisho. We really appreciate your assistance. Okay, then we're back at the minutes or setting the agenda. Does anyone else want to add something to the agenda? Okay, nothing else. Can we then move to the minutes of the previous meeting? Is there any corrections or comments that we have to look at? That was the meeting where Rian Leroux presented the how to create a website, and he gave us all those valuable information how we can do that.
Matilda, he is typing with opening and welcome. The chairperson welcomed everybody. Everybody is one word.
Okay, we'll just rectify that.
And then also on the second page, almost to the end, just after those links, there's a few handy tips given by Mr. Leroux, included or includes. Something is not right there.
Yeah, I think it should read including the following.
Yeah. And then just the second bullet, copyright. I'm not sure if copyright is not one word.
Okay. My husband is a language guru. I'll ask him tonight, but mostly in English, if I'm correct, words are spelled separately, but I'll ask Kobus just to confirm and then I'll come back to you. Or
Copyright is one word.
Is it one word? Thank you,
Yes.
Esma. Esma, thanks for your comment. Okay, can we then adopt this meeting as a true reflection of our meeting of last year, 10 June?
Since I didn't compile the minutes, so I can say yes from my side. If you can just have a second.
Yes, yes.
And then
Thank you.
Esma is the seconder. Thank you so much. According to me, there's no matters arising. Am I correct, Erno, or is there something that we need to look at?
Not from my side.
Okay, then we move to matters of the day. The first point on the agenda is our finances. I think in the previous meeting, I also reported that we have 511 Rand. Due to the fact that we are currently not paying because we are all drinking our own coffee or tea at home or at the office, there's no income, therefore the amount stays the same. Arna, will you please just inform the meeting about the membership? And I hereby appeal to everybody, please promote our interest group. Currently, we don't have that many members. So whenever you are dealing with other colleagues, please just tell them about LISLIG. Arna?
Okay, up till now, that was actually not now today. It was about 2 weeks ago, towards the end of January, beginning February. We were, for LISLIG Free State, we had 9 paid up members. Now, I cannot confirm if it's the correct amount or the number, because I haven't got confirmation. I will make sure about that, but that is people that were previously members of LISLIG, and I saw on a membership list for the Free State, they renewed their membership for this year. So I'm just taking it that they are still staying with LISLIG. Then we also, like always, for our LISLIG Free State invitations, we sent it out to everybody that we can think of that will have an interest in the LISLIG activities, like people that are in the special libraries in the Free State that are not members of LIASA. So we also send it out to those. So our membership, our address list is longer than our formal membership list. And like Matilda just said, please, if you know of anybody working in a specialized library that would like to join us, send the information to me, and then I will send an invite to them to ask them to join us. It will really help us to spread the word. I think that's all at this moment. Thanks. And then pay your membership if you haven't paid yet. Thanks, Matilda.
Thanks for that reminder, Erna. Then the next point is meetings for 2022. The next meeting will be on 28 April and the theme is gamification. The meeting after that will be on the 16th of July. And at this stage, especially for our both those meetings will be Zoom meetings because we have speakers from Gauteng who will assist us with those 2 meetings. So both of those meetings will still be Zoom meetings. Okay, then we are at number 7. That's where we get our speaker, which is Carita Visser, who will give us some more information on how does the POPI Act affect your work as librarian. And I just want to say, do you all know that POPI stands for Protection of Personal Information? And it's very interesting, this act comes from 2013 and it was only promulgated in 2021, or was it end of 2020, Carita?
2021.
2021. So yeah, this act took a very long time to come into existence. Carita, thank you so very much for availing yourself. We are really looking forward to your talk to us. Carita has done an LLM and then has a dissertation was on the POPI Act. So I'm sure she is in our midst. She's the person with the most knowledge, and we will certainly learn from her today. If I just might ask a few household rules, if I will switch off my camera just now, and if anyone else's camera is on, please switch that off. And then Carita, what I thought of is I'll ask everyone to, if they have questions, to put it in the chat box. Then afterwards, we can just look at all the chats, and then I'm sure she will answer all our questions. Carita, we are really looking forward to your talk, and the floor is yours.
Thank you very much, Matilda. Good morning, everyone. I'm very excited to chat to you about POPI. And in my experience, I just always start out by calming everyone down. Privacy as we know it hasn't changed that much. And it's not the end of the world, and it's not a very expensive act to comply with. You're not going to have to gooi die baba uit met die badwater. So I just always start out by saying POPI is not here to make our lives more difficult than it already is. I'm going to turn off my camera as well. Then there's no distractions, and then we can focus on my PowerPoint. And then I do have a slide for questions later on. And then if you're struggling to hear me, or if you can't see the screen, I am screen sharing at this moment. Please just holler, then I can know. Great, so we're going to get started, and I'm going to try not to bore you too much with nitty-gritty details so that there will be time for questions. Okay, so thank you for introducing us to the name of the Act, Matilda. It is the Protection of Personal Information Act 4 of 2013, and it only became fully enforced in July 2021. And before that, a few of the sections came into being because the information regulator had to be created, but we'll get to that later. So I started out by saying POPI isn't a reason to panic. because it's not as if our right to privacy only started with POPI. So before we had this act and before the internet and the information age, we already had the right to privacy. And in the South African legal system, that is part of what we call our common law. And then in 1996, we got our constitution, which also enshrined our constitutional right to privacy in section 14. And then we saw that other countries are starting to get laws and acts, or the European Unions as well, about data privacy. And we had to keep up with international trends. Apart from the fact that we are also moving forward, and informational privacy has to also develop, and the Constitution says that our courts and our government have to take steps to protect these rights. POPI was also enacted because other countries' privacy laws requires countries with which they communicate and send records to have almost similar protections. So it makes sense. People have asked me, are we trying to enact a first world law in a developing nation? And I said, no, we have to do this. South Africa will not be able to do business in other countries or other continents if we can't show that we have a law in place that protects information and that regulates the flow of information across borders. And then it's good to start or end with this slide. Should we really care? We should. We should care about POPI and we should take it seriously, but we shouldn't be scared. Personal information and the trust people place in you for collecting and processing their personal information is an asset. And it's very closely linked to your reputation as an organization, whether it's a library or a school or a church. And then also this all has to do with good governance of your organization, of your library. Information governance is part of good corporate governance, and compliance is just a part of that. You can't talk around that. You can't forget about it. Compliance is important, and this leads to savings, increased productivity, and better decision making. It's just a holistic approach to governance. It's also an opportunity to be socially responsible, and it doesn't have to stop at personal information. Principles here, I think, can enrich your life in other ways as well. Okay, so now we get to the actual act. I'm not always going to refer to specific sections, but if you want me to, you can just pop it in the question box and then I will check what the specific section is. But it's important to start with the application of the act and the exclusions of the act, because POPI isn't applicable in all instances. It's definitely applicable to libraries, but let's just get down and dirty with what the act actually says. So it's applicable to personal information that's processed where the responsible parties in South Africa. I'm going to get to the terms later, like what is processing, what is the responsible person, what is a responsible person as well. It applies to personal information that's being processed in South Africa, not just to South African citizens, and it also doesn't just apply to people. Natural persons is the legal term we use. It can also apply to a juristic person, such as your library or your church or your school. You also have a right to privacy. However, sometimes there are regulations or other statutes that also regulate the right to privacy. And POPI says if there's a clash, the act that offers the most protection is applicable. So an example I can give is POPI says you're not, and we'll get to record keeping, but I just want to give an example. POPI says you have to keep a record for as long as you are mandated to do it, for as long as you need it. But then if you are a teacher at a school for learners with special needs, their regulations in terms of the Health Professionals Council of South Africa says you have to keep records for the whole lifetime of the child or the mental, I think they actually refer to them as mentally ill patients. So the regulations or the rules where the most protection applies, and then POPI applies to information collected before the effective date, which for purposes of this section was 1 July 2020. 2021, sorry, no, 2020. Sorry, I lied to you earlier. So that means if you have records that you've been keeping for 10 years or for 5 years, they have to be protected in line with POPI Act. Okay, even though you collected them before the act was enacted. Okay, great. Then you can see on the other part of the table, section 6 of POPI Act deals with the exclusion. So it's not applicable to the cabinet or the committees or any of the executive councils or any information relating to the judicial functions of a court. And that makes sense in order for the court to fulfill their mandate in terms of the constitution and legislation. They need access to information. And then, of course, our government and cabinets, and they need to have a free flow of information, and they also have other common law principles there that give them protection. Then, of course, if it's personal information that you are processing purely for household activity, POPI is not applicable. For example, your WhatsApp groupie that you have with your family, you do not need to send a POPI consent waiver on the WhatsApp group. That's not necessary. If information has been de-identified, I think that is pretty self-explanatory. If it has to do with crime, security, national security, the police, POPI is not applicable. And then data for literary, journalistic, or artistic purposes, also not applicable, even though the Act doesn't define that. So it's still a bit of a gray area, and that will be like a case-by-case basis situation. So let's just quickly look at some POPI terminology. I just actually want to go back to the journalistic purposes. We all remember in January there was a court case about the matric results having to be published, and then people, the Department of Education was like, no, POPI, we have to protect the children's right to privacy. But in that case, the information was de-identified because it's only the exam numbers that was being published. And then they did go to court, and I haven't found the judgment, so I don't really know what they were. The order was granted that it has to be published in the newspaper, but that's an example where we can see POPI isn't applicable, but that everyone had a kind of a freak out about it. And POPI isn't there to restrict the flow of information in that sense. Okay, I'm not going to read the whole definition of personal information, but it is defined in POPI, and as I put it on the slide just so that you can see, it is very wide. So you have to know what personal information is if you're dealing with this act. So it's very wide, and I just want to show you that it is information relating to a living natural person. So if it is someone who has passed on, POPI is not applicable. And then also, if it is, in certain cases, it's applicable to an existing juristic person. So an existing company that hasn't been deregistered, okay, for example. And then you'll see a whole list of things here that basically it's about identifying someone, whether it's one thing like age or everything. Okay. I'm going to move on, and I will send the slides to you if you want to read what the whole definition of personal information is, but it's very wide. Okay, in processing, it is important to know what processing means, because that's what I'm going to refer to throughout the whole chat about what you will be doing with data. It's also a very wide definition. So if you're dealing with personal information, or sometimes I refer to it as data, even if you're just collecting it or storing it, even if it's just a file lying on your desk, you're collecting it, you're storing it, that is in line with the definition of processing in the Act. So any operational activity, whether it's you're doing it by hand or it's a computer that's doing it, or rather not a computer, let's just use the terminology in the Act, automatic means concerning personal information. Collection, receipt, recording, organization, storage, updating, if you're distributing it, if you're merging it, if you're destructing it, deleting it, you are processing personal information as defined in the Act. A responsible party is a public or a private body or any other person which alone or in conjunction with others determines the purposes of and means for processing of personal information. So that would be, for example, I'm using schools as an example because I'm dealing with a lot of schools at the moment. And the responsible party will be the school governing body together with the Department of Education. Okay, the responsible party of a church, for example, will be the board of the church. Sorry, but sometimes it is just one person. For example, if you are in a library, it might just be the head librarian. I don't know how this, yeah, it depends on, I guess, whether you're like a private library at a school or whether you're a public library, who the responsible party are. But it's important to know who it is, because when it comes to liability for non-compliance and for compliance, the responsible party is the person that bears a lot of the responsibility. An operator is a person who processes personal information for a responsible party. So that would be a lot of the time the employees, or sometimes it's then applications you use or software you use, perhaps, or an app you use that processes the personal information, or maybe enters it into the computer or sends out the email. They are the operator, and they are not as liable for like damages in terms of the act. Great. Now we get to where more direct responsibility lies, is the information officer. So every organization must appoint and register an information officer. So the act actually, usually it's automatically like the director of a company, but they can appoint deputies, and we'll get to that later. The information officer has it seems like a lot of responsibilities, but it really can be explained by just saying the main duty is to monitor compliance with POPI. And the information officer is not a new concept in our law. The Promotion of Access to Information Act also provides that an information officer must be appointed. So even though the Act is numbered 2013, in 2018 we had regulations already to explain what the duties of an information officer is. And you can see there it is to develop and monitor a compliance framework for POPI, to do a risk assessment, to compile a PIA manual, that's the Promotion of Access to Information Act, and then awareness sessions and internal measures and adequate systems developed for requests. That's requests regarding access to information. But we'll get to that a bit later. So the information officer has a lot of or it seems like they have a lot of responsibility, and that's why it's important for them to know what's happening in POPI. And then the registration happens on the information regulator's website. I'm going to get to the information regulator now. And that is also net gesukkel. The portal crashed, and I know of a lot of people who haven't even been able to do that, but there's no deadline because the portal crashed. So if you don't have an information officer in your organization yet, don't worry, you still have time. Okay, but POPI created the information regulator, and this is like the POPI police, but don't think of them as the police. They have a lot of powers, but they are there also to educate and to assist. So they have to provide education, monitor and enforce compliance. They consult with interested parties, and they receive complaints, and they conduct research, and they report to Parliament. And they are also taking over some of the responsibilities of the South African Human Rights Commission. The South African Human Rights Commission had a lot of responsibilities connected to the Promotion of Access to Information Act. So I think that's a good move. Everything is central. I do suggest you go check out the Information Regulator's website if you are interested in this, or in privacy, or maybe you are the information officer of your organization or your library, or in another setting. The Information Regulator's website has guidance notes that are very helpful. And here I just have a screenshot to show you that the portal on the website isn't currently working. It just created a lot of panicked phone calls for a couple of months, but I'm also not surprised. Great. So now we get to how does POPI affect your work as a librarian? And the answer to that can really be found in Chapter 3 of the Act. And Chapter 3 has the conditions for or of lawful processing. Now, these conditions, it is not something that our legislature just sucked out of their thumbs. These conditions really are in line with international standards, conditions or requirements for lawful processing of personal information or data. For example, it is very similar to the conditions set forth by the General Data Protection Regulation, the GDPR of the European Union. A couple of years ago, we all received constant emails from websites about their privacy policy that was changing. I don't know if you perhaps remember that, but that was, for example, when the GDPR became a thing in the European Union. So that's where that came from. And then, of course, with POPI, I'm sure you received emails and notifications about that as well. So here we have the conditions. I'm not going to read them straight from the Act. I'm going to just explain it informally and focus on every condition. And then maybe, or at the end of all the conditions, I'll be focusing on the ones that are the most important. But when you are acting in the library, in whatever position you are, and you're dealing with personal information, whether it's of a colleague or a service user or a client, or maybe even a third party that you're contracting with, like the people that bring the water cooler, you have to keep this in mind, the conditions for lawful processing. So the first one is accountability. Sorry. I just want to move that. Okay, so even though the responsible party is responsible for complying with these conditions, every person involved in the processing of personal information has to do it in a lawful manner. And lawful manner, it's these conditions that I'm talking about now. So accountability means you're accountable for what you're doing, and you know you have to be responsible, and you know you have to comply with these conditions. So it basically means it has to be in line with POPI and its regulations. Regulations are also published, not as many as with the Disaster Management Act. It's a lot less confusing to navigate. And that means you have to be up to date with the regulation. So that's why I said you should keep an eye out on the Information Regulator's website, because they do break it down into digestible, what they refer to as guidance notes. So accountability is just one section in the Act. It's section 8, and it's not long. The other conditions are a bit longer, but it basically just means that every person involved, but you know, if the POPI hits the fan, it's going to be the responsible party that's held accountable. Great. The second condition is processing limitation, and you can find this in sections 9 to 12 of the Act. So it's about the lawfulness of the processing, about minimality. It's about consent, and where you are finding this information from. But to break it down into digestible information, two of the important questions you ask yourself is, what is the least amount of personal information I need to process in order to fulfill the mandate? What do I need to do my job? Is it more than what really is necessary? And then secondly, what did the data subject consent to? Did they consent to the processing of all this information? And did they consent to the processing for this specific purpose? Okay, so for example, I will email you the slides today, and perhaps I'm CC'd in an email and you see my email address there. You can assume I'm consenting. Please communicate with me for the purpose of this talk, but please don't use my email address to sell me Avon products. That's not why I sent you my email address, if that makes a bit more sense now. And this condition is very important, and under this condition, a lot of paperwork comes into play. Whether it's paperless or not, it's a bit more admin. The next condition is purpose specification. So you must process the information for a specific and a defined and a legitimate purpose. You can't just keep someone's personal information because you might need it one day. You have to ask yourself, how long do I need this information? And then when I don't need it anymore, how am I going to get rid of it? If it's a hard copy, am I going to shred it? Am I going to recycle it? How am I going to format this computer? If we are throwing away this computer, are we formatting the hard drive? Yes. So a specific defined legitimate purpose. For example, you are collecting the personal information of service users in your library onto your system. Do you need to ask questions about their marital status or their blood group, their blood type? It's not necessarily necessary for you to fulfill your mandate in whatever role you are fulfilling in your organization. Yes, so this condition is also, it's section 13 and 14 in the Act. But we'll get to the retention of records a bit later. I just want to run through the conditions first. Okay, and then the next condition is a further processing limitation. And we can see these conditions are very intertwined. They're very much married and work together. But further processing limitation is section 15 of the Act. And it basically says information may not be processed for a secondary purpose. And it means that the data subject must be aware why is information being processed. For example, is it in line with the purpose for what it was freely provided? I gave you, yeah, it comes back to my email address example. Why did a client give you their personal information? You are only allowed to use it for that purpose. Next condition is information quality. Make sure the information is correct and up to date. That's your responsibility or the responsibility of the responsible party, but it also rests with the data subject. Do they know how to update or correct their information? And then, of course, just information coming directly from the data subject is the safest way to make sure it is correct. It is actually not at all advised to have someone else provide their personal information on behalf of someone else. So this is quite important. And I think we always forget, like if, yeah, it's something that you can think maybe is not that important, but I would like to know, how do I check what you have on me and how do I correct it? Okay, for example, how do I change my surname if I got married? That is about the quality of the information. You want it to be correct. Then openness is another condition, and that's section 17 and 18 of the Act. It just means transparency with your privacy policy. Inform the data subject about where your policies can be found. They have to know about their rights in terms of POPI. And do you have proof that you obtained permission or consent? And we're going to get to that with the POPI plan in a minute. Then there's a condition about safeguards. That is section 19 to 22. Yeah, what safeguards are you keeping to keep information safe? Does your staff know about POPI? Does the technical team know about POPI? Is your system safe and secure? We're going to get into nitty-gritties later when I talk about the practical implications of POPI, but these questions are important. How secure are your computers? Or if it's in a cabinet, how secure is it? How secure is your building? And how are you going to proceed if someone accesses your system in an illegal way? The safeguards must be determined, and that will be in the POPI plan, which I'll chat about now. Condition 8 is data subject participation. This is very linked to openness, like communicate with people whose data you have, your employees, your colleagues, service users, clients, whatever you call them. What information are you processing? How can they get it? Their rights and their responsibilities. And this is information you will be providing in your POPI manual and in your PIA manual. It seems like a lot of paperwork, but there are templates out there and the information regulator assists you. But it's really just about being very open about this is the data we have, this is what we do with it, this is when we get rid of it, and this is how you can access or request access to it. And it's, in my experience that I've assisted people with drafting their manuals, it's just a lot of drafting of things that not a lot of people are going to read or care about, but we should care and we should comply because we want our service users and our colleagues to trust us, and it's something you have to check off the to-do list. So here's lawful processing in a nutshell. Firstly, obviously you have to ask yourself if this is personal information. If it's not, POPI is not going to be applicable. And if it's personal information, that also doesn't mean that POPI is applicable. So then we go back to the applications and the exclusions. Okay. And then the most important questions I want you to remember from the conditions is, what did the data subject consent to? Do people have access to this that need it? How can I minimize that must be the amount of personal information. Is this information safe? And when won't I be needing this anymore? So this slide, in my personal opinion and in my experience, sums up what POPI requires you as librarian to change in your thinking when you're working with personal information. Now, I just quickly want to pause on the personal information of minors, because POPI is a bit more strict about that. So section 34 and 35 should be read together. And it basically says there's a blanket ban on processing the information of children unless a guardian or a parent consented to that. And that is where a lot of the paperwork for schools came in now. So section 11 of POPI this is probably the section I work with the most. That deals with consent from the data subject, or as I said just now, in the case of children, from the competent person. So it says you can't process information unless you obtain consent, or you do not need to get consent if it is to carry out actions for the performance of a contract, if it is to comply with the law, if it protects a legitimate interest of the data subject, if it's necessary for a public body to properly perform their public duty, and if processing is necessary for pursuing the legitimate interest of the responsible party or of a third party to whom the information is required. And then, just important, the responsible party bears the burden of proof that they have obtained consent. So it doesn't say that you have to have a consent form in writing, but it does say, if there is a dispute about consent to process my personal information, the responsible party bears the burden of proof. So in practice, it is good to get it in writing. So this slide is very important. Obviously, you're sometimes will be working with the information of minors, and then you must have their parents' consent to have their information in your system, or if you're to process their information. So if we're looking at the slide where consent directly from the data subject isn't necessary, that is, for example, to comply with the law, to carry out actions for performance of a contract. An example that's good to use is when you're dealing with children. We all know we have to look at the Children's Act and well, anything to do with the Child Justice Act, for example, and you're a social worker or a teacher or a doctor, and you see that a child's life is in danger, or you see signs of abuse, or there is just a crisis, there's an emergency, and you have to call someone and report this, whether it's the police or a parent, or you have to take them to the hospital. Then you have to, firstly, you're performing a public service. You have a responsibility as a social worker or as a teacher, but you're also complying with the law. The Children's Act says we have to act in the best interest of our child. Or you can even say that it was, POPI is then not applicable. You can't say, I'm not going to report abuse of a child because they didn't consent, if that makes sense. And then I just want to I want to pause on consent for a couple of more minutes. So you have to require, do you have consent? And does it cover the processing you're currently doing? And if it doesn't, does the rest of the sections in POPI cover it? Okay. But it's not allowed to be excessive. That's also very, very important. So let me use just a regular library example. I gave you my information, my contact information. So I don't know what you guys do. Actually, I wanted to ask before with fines, with library fines. Do you ever take it to either to the police because it's theft of books, or do you collect debt collection at like a law firm? But let's say you do, then obviously you're going to give if I owe you as a library money, perhaps because I took out a book and I didn't bring it back, or because maybe you provided services to me, I gave you my personal information, you're going to need that to eventually sue me for the money. The sheriff is going to bring me the summons and they're going to need my address. I don't need to consent to that. They need that to fulfill their mandate in terms of a law and because they're a public organization. I just want to quickly also pause on legitimate interest. This is also where the matric results kind of came in. So legitimate interest isn't defined in the Act, but it is kind of a defense against lack of consent, which is kind of a way around not having consent. And it is a perfect example where you will be using someone's personal information to make sure they perform in terms of a contract. A lot of the time it's about payment. But I will send you the slides and then you can read a bit more here. So here's an example about like if someone owes you money, you have a legitimate interest in the matter. So you're allowed to use their personal information to send them a letter from an attorney telling them you owe me money, you have to pay me within 2 weeks, for example. And then another example would be where the user has requested the deletion of their data or to unsubscribe from a mailing list. In order to ensure that the user remains unsubscribed or that another user doesn't use that email address, the data processor may retain the details necessary for furthering that legitimate interest, if that makes any sense. And then I already spoke about the processing of personal information of children. So the parents have to consent, or if it's necessary for a defense or obligation in law or international law or for historical statistics or research purposes and all that. But my advice is always, if you're dealing with children, to get consent from the parents. Just be safe, and it's just good practice. Okay. Now we get to the less boring part. So for POPI in practice, how will this affect your day-to-day life? And I also want to say, if you're working somewhere, part of an organization that hasn't done these steps, don't freak out. That's not going to help. You can start the process now. So as stated, you will first have to appoint and register an information officer, and then a risk assessment will have to be done. You have to draft a POPI policy and a POPI manual as well. You have to check your agreements with your product suppliers or insurers, for example, if it's applicable. If you have a storage unit where you keep records of personal information or of your employees, make sure they also have a privacy policy in place. And then employment contracts have to be updated. I always suggest just adding a clause to, or like an addendum to employment contracts where all employees, or like even if it's just an intern, also commit to complying with POPI and to not processing information in an unlawful manner, which basically just means you're not going to share information of clients or service users unless it has to do with work. So the information officer isn't alone in this POPI compliance game. You can appoint a deputy information officer. So that can be anyone in your company, and you can delegate, well, anything to them. So it's not just in terms of, it's only in terms of POPI that an information regulator can be registered, but you can delegate the PIA, the promotion of access to information functions, to them as well. And then just a side note, POPI extended that to private bodies as well. Because now we get to the risk assessment. So we were looking at the process of compliance with POPI and how it's going to change your work as a librarian. Your company and your employees, before you start thinking about a POPI plan, you have to do a risk assessment. You have to kind of ask yourself, what are we dealing with? What personal information are we dealing with? What do we use it for? Do we need it? Do the data subjects know that we have it? Perhaps we can de-identify it. Are we satisfied that we have security system in place? Who has access to what data? Is the data accurate and up to date? How do we delete it? Who's the information officer? And do we keep record of processing activities? I would say this list is a really good place to start. And I'm sure now that you've heard the conditions, you will agree with me that it covers most of that. Part of your risk assessment is the physical security. Who has keys to the building? Who has keys to the cabinet? The digital security. Do you have a virus software on your computer? Do you have a clean desk policy? If people walk into your office, is there just personal information strewn about, or do you file it away when you're done with it? Do you have a personal cell phone or a work cell phone? If you do, just put a pin on it. That's reasonable steps you can take to safeguard information. You don't have to buy the most expensive virus protection, but you have to start thinking like this. If you're taking work home and it has personal information on it, are you making sure it's not lying about? Do you have CCTV on your premises? Is there perhaps a sign up that informs people? We have CCTV. It's only for purposes of security, but please note you are being recorded. Do you make social media posts? Do you take pictures of people, service users or employees, and post it on social media? They have to consent to that, unless it's not for a personal or a household activity, like on your personal Facebook. But if it's on your company or organization's Facebook or social media, you have to obtain consent. And that's my advice, always obtain consent, and with children especially, have a waiver that their parents sign. For example, sometimes a church would make a video of the kids at an event and then they play it later for marketing purposes. You can't do that unless you have consent from the parents. There's this story I heard of so when you're done with your LLB, you go to clerk at a law firm, then you're a candidate attorney, and it's very rough. It's 2 years where you pretend to know what you're doing. And then this candidate attorney, somewhere in a very big firm in Gauteng, she was in her office and she just took a selfie to post on her Instagram to be like, I'm in the office working, what. And on the table in her office was very confidential information about a merger that was happening. And in the end, it got leaked and everything just ended in disaster. And she got fired for misconduct. So that's really worst case scenario. But that is the way I'm starting to think about how I'm processing information. Okay, so now you've done a risk assessment. You kind of thought about what data are you dealing with. You've chatted about it, and now you can start with your POPI plan. And it's going to sound a lot like the risk assessment, and it's really connecting back to those conditions for lawful processing. Okay, you can see this is a lot like the risk assessment we just did. And it will literally have these headings, be like, who are we? What data do we have? What do we do with it? How can you find out how to access your information, to edit it, or to do a quality check? And I've helped a few people with their POPI plans, and my opinion is that it does not need to be too complicated at all. If you do go look at the Act, you'll see there's a section on Code of Conduct. It's not compulsory, and I also don't suggest doing it unless the minister publishes a regulation that says your profession needs a code of conduct. So just so that I touched on it. Then I've been touching upon the Promotion of Access to Information Act, POPI. So there was also a lot of confusion about this. So it's two different acts, the POPI Act and the POPI Act. Both of them require you to have a plan or a manual for compliance, and both have to do with information. POPI has to do with personal information, and POPI basically has to do with access to information and records that you keep. And that isn't always personal information. Sometimes it can just be about like computer logs or about vendors. Is that how you say it? Sorry. Okay. So you also, if you're a public body, you must have a POPI manual. Private bodies had until 1 January 2022 to make their POPI manual available, but I know a lot of people don't have it. So this manual is about the records, how can people request it, and I will send you the slides, but there is a guidance note on the Information Regulator's website to kind of just make us a bit less confused about, can we make this manual one thing? And that's what I do suggest, is usually it's a POPI and the PIA manual in one document, and there's a lot of overlap. So you might as well make it one document. And then, as I stated, the PIA stuff was the South African Human Rights Commission's ish, but it has moved to the Information Regulator now. Okay. This also doesn't have to be very complicated. It's a bit boring, a bit more boring in my experience than the POPI manual, but it's also something that has to happen. And previously you had to register your manual with the South African Human Rights Commission, but on perusal of the Information Regulator's website, I don't see a place currently where you have to register your manual. Your manual has to be available on your website or on your premises. And I don't want to say without checking, but I almost think a public body has to have it available in more than one language, but I'll have to check up on that. If you have any questions, you can just let me know. Also, very much important, keeping of records. I just also want to highlight this. So you are entitled to keep a record in terms of POPIA if legislation requires it, if it is operationally required. For example, I need this to do my job. If a contract requirement, and if you have consent to keep it. So you have to know how long to keep it for, okay? For example, very silly example, you have a business that comes in to do your cleaning. You have their information, the juristic person's information, and the contact details of their employees, maybe in your system or your filing cabinet or on your phone. And you need to have that information because it's required for you to do your job. And in terms of that contract, you need to be able to contact them. So you don't necessarily need to get their permission. But if that contract is cancelled or terminated, you don't need that information anymore. So then you destroy it in a safe manner. You delete it or you shred it and you recycle it. Okay, so now I have a bunch of slides about non-compliance, but I want to, let's just quickly. So if you don't comply with POPIA, I found that some lawyers or organizations that have to do with compliance, they just call people and tell them you can get a fine of X amount and what, but just in terms of non-compliance with the Act, we've talked about all the stuff you have to do. If you don't do it, what's the worst that can happen? It can be quite an expensive exercise, but the Information Regulator has a really wide array of powers when they receive a complaint. And even in the event of non-compliance, I always suggest that your own internal policy makes provision for complaints first. But I don't think that's that, but like when I was working in litigation department, I thought that was really good advice. So I'm almost going to get to the questions part, but so we're talking about non-compliance. We talked about all the stuff you have to do. What if you don't do it, or if you do something wrong, or there's a breach? The Information Regulator will receive the complaints. So you're not allowed to run to the police about a privacy breach. The jurisdiction is now with the Information Regulator, unless a crime was committed, okay, unless it was security breach in terms of the Cybercrimes Act or whatever. But the Information Regulator will be your first stop. There's a prescribed form that you have to fill in. You can go on the website. I've actually lodged 2 complaints on behalf of FETSAS against the Information Regulator and have heard nothing back. So here I just have a quick overview. So you see, this is what the Information Regulator can do when they receive complaints. It doesn't say you're gonna receive a fine immediately. You can see they have so many steps that they can take. They can take no action, which it will probably happen in most instances, right? There's conciliation, there's settlement, there's a pre-investigation and a full investigation. They can refer it to another regulatory body. For example, if you are a social worker, they will send it to perhaps your ethical board, or if you're an educator, perhaps to the South African Council for Educators. So I will send you the slides. There's a bunch of slides coming up now that really kind of focuses on each of these aspects. I don't think that's necessarily necessary, but just so that you can see, the information regulator is not going to come banging down your door immediately. There's a lot of in-between stuff that happens. Okay, so if there are any questions, you can start typing them in the chat box. Otherwise, I can talk about non-compliance a bit more and the fines and damages and what. Otherwise, I think you can, or you can raise your hand. Yes, Manda or Manda.
Can you hear me?
I can hear you.
Okay. What I want to know, we do lots of sorry, I'm from Kimberley, in the Kimberley Library and Research Services. So we have lots of public libraries and we do lots of outreach programs. Okay. So usually we take photos of every program we do with the children, and we have like attendance registers. And then we put it on our Facebook pages. So now what I want to know, are we still allowed to do that, or because the parents are usually not present? So do we have to have the consent to put it on our Facebook pages? And other thing, we get grant funding from the Department of Arts and Culture, and we have to do outreach programs, and we have to give them a portfolio of evidence, like the photos and stuff. So how do we handle this now according to the Act?
So if you are processing the personal information of children for your own page, do they usually come with the school, the kids?
Sometimes it's schools that come. We do school programs, but then in the holidays, we have like holiday programs. Then the parents just drop the children at the library, so they come on their own. Yeah. So it's different programs.
Well, my advice, as I said, always, if it's a Facebook or social media post, you need to get consent. So if it's perhaps teachers that are coming with them, that might be sufficient, because teachers are what we call in loco parentis. They are in the position of the parent. But if it's during the holidays, I definitely would advise you to get consent, or to have a sign up that says, by dropping your child off here, your consent, we will be taking pictures, which might be posted on the social media page. Or you can make that sort of just part of the registration process. If the parents have to RSVP, you can have a notice about that. So if it's going to be posted on the Facebook page of the public library, please do get consent. That's my advice. But if we're moving to the portfolio that you have to provide with the photos and stuff, I would say then you are performing a duty in terms of a mandate as a public organization. And then in terms of Section 11, consent isn't necessary. But my advice always with social media is to get consent in writing. And I can send you an example of a waiver form. It's not complicated at all. And I know it sounds like a lot of admin, but shoot, we have to protect our children, and social media is just a minefield. So yeah, that's my advice.
Okay. Yeah, just one other question. Sometimes there's children that just come to the programs and you don't see the parents, or like at some of our libraries, there's just children the whole time. So what do you do in that case? You just don't take the pictures, or you just ask them not to be in the picture? What do you do then?
Perhaps then you can just hide their faces or take a picture from behind. And that would be my advice. Okay. Yeah. I know I'm sounding a little bit strict and over the top, but yeah, that's my interpretation of POPI and social media. Yeah, so maybe you can kind of get around it by doing that. Take the picture from behind, or blur out their faces, or stuff like that. Okay. But I see there's a question here. What if we take photos, adults or children, and publish this in our newsletters? I'd say then you can argue that that's kind of for artistic or journalistic purposes. So then you don't need to get permission. And that newsletter will be forwarded to interested parties. So then I don't think it's that necessary. What about just to put a black part over the eyes? Shouldn't that be enough? Thank you for that question, Hesma. Yes, if the black part over the eyes is enough to kind of de-identify the child, yes, then that's fine. Yeah. Sorry, I just want to scroll if there's any other questions that I'm missing. I don't see any other questions at the moment. Yes, Dora.
Good morning or afternoon. Where are we now with the time? Thank you for this very informative session. I'm much more familiar with the POPI Act. So getting familiar with POPI, she's a new girl in town. So yes, we all need to know her ins and outs. I have two questions. I'm at academic library. So we have our own POPI manual, and the question is regarding, I want to call it the database, the central database of the institution, where all the student and staff records are kept. So we as the library, the first part of the question is we download the records, the student and staff records, into our library system to allow us to issue books to legal, actual, because it also includes the expiry date of the client. So if the student is registered until the end of the year, or they resigned at the end of the month, then that information will then be included. So that will then hamper us from issuing books to people that are no longer associated with the institution.
Yes.
But in our POPI Act, it states very clearly, for instance, the ID number does not appear, we don't pull that through. Is basically the student numbers, staff number, name, telephone numbers, and addresses.
Okay.
So for the purpose of communication, things like that. So how does that then come back to the POPI Act? Or do we only rely on the POPI Act? Because the POPI Act already states what information we can give out, because we as a library, it's stated in the POPI manual, what we as a library can then give out. And for instance, we can't give out if there's a client in front of us. Just have a look up that one's telephone number. Can you please give that to us? So that's not permissible. So does the POPI manual already cover the POPI? Because you've mentioned combining the two.
Yeah.
So yes.
Yes, it does cover that. It's exactly, yeah, there's a lot of overlap. So if you're already stating what data you are dealing with and what authority you have to do with it in terms of dissemination, then you have already covered that aspect of POPI. So yeah, a lot of stuff that is in the POPI plan that's not in POPI is maybe a bit more of the safeguarding, the materials what you and style and stuff like that. But it can, in my opinion, and I have advised people, it can be one manual. And I will send you the guidance note. Yes, but there'll definitely be stuff that has to be added. Does that answer your question?
So that, yes, I think so, because in that sense, that is definitely part of us as a library, our responsibility, not giving out that type of information, whether it's under the POPI or the POPI Act. We must restrict the giving out of information, and that it's not just for academic libraries. I think it's for all libraries, that we know that we don't give that type of information. And then the second question is about our databases, because I get a lot of these questions when we do our annual renewals, and then our legal guide, legal eagles always tell us, okay, now what about the POPI Act? Now what happens? We have on-campus and off-campus users, and both on-campus, if you're using a computer in this facility, your IP address of the computer will say, yes, you are a CUT client. So if you contact the database vendor, the database vendor will verify, yes, you are a CUT client, so you don't have to worry. You could come through and come and search on the information. If it's off campus, once again, we have a system in place that verify via our central database, if I could call it that, if that is still a valid client of the CUT. If so, then they can come through. But now so no personal information is really going out to from the institution to the database vendor. But where it comes a little bit blurry is then an individual can then register themselves on the database to allow them to save information, to make notes, for instance, an ebook, make notes on the book, make highlights. So if they then go back to that database, then they can see, oh, I've already read this book. These are the notes on the, like for instance, a lecturer, for instance. So now the concern of the Legal Eagle team is that type of personal information that the client then provide to the database vendor when they register themselves. That is that sits in their own domain. That has nothing to do with the institution. Am I correct in saying so?
Yes. In that situation, you are not the responsible party anymore because they have their own policy, the database.
Yes.
And perhaps they won't even be domiciled in South Africa. The actual servers won't be in South Africa. So then POPI isn't applicable. Yes. So then sort of your responsibility is perhaps just informing them, listen.
Yes.
Yeah, we're not processing information. This is not responsibility of this person in this instance. Yeah, that's what it sounds like to me.
Yes.
Yeah.
You see, because it becomes a little bit iffy with all these technical things. But yes. So no, I just wanted to confirm.
Also, I want to add, like, they are also processing that information to fulfill a contract that you have with the database or a legal agreement. You're going to assist our students. So they are collecting information to fulfill their mandate. So there's also kind of like a loophole in terms of consent and stuff.
Yes. But that is not personal information that we provide to them. That is generalistic. We have a faculty of engineering, a faculty of this, or what you understand, that it's more general information. It's not you as Carlita, as that is your information. You belong to that faculty, that department.
Okay.
It's only when you register yourself that information then comes into play.
Yeah, it sounds like I interpret it in the same manner that you do. The process from you to the database.
Yes, yes. Okay, thank you very much.
Pleasure. Any other questions? Just checking the chat box. I'm not seeing any other hands. Matilda, is that a sharp or a question? Yes, Matilda.
I'm not asking a library related question, but something that's very interesting for me is I thought when the POPI Act came into place, we will stop getting these people phoning you or these phishing emails that we receive. So under where does this fall into? Because who is still giving out my information?
POPI definitely has an influence on direct marketing, but the Consumer Protection Act also adds more protection there. But the basic answer is they're allowed to call you once, like the political parties, for example, as well. They're allowed to call you once, but then you have the right to ask them, where did you get my information? Please delete it. Please do not call me again. I had to answer this question the other day. I can't remember why I'm telling you they can call you without you having giving out your information. But direct marketing is allowed in terms of the Consumer Protection Act. It's just not allowed all hours of the day, for example. And then my advice is block them from your phone or unsubscribe on the email or ask them to delete your data. And if the option isn't there, then you can complain either to the information regulator or to the consumer tribunal. I hope that helps. Yes, Songezo. You can, I think you just have to unmute maybe.
Good day to everyone. Songezo from the University of the Western Cape. There was an argument. In fact, I attended a webinar, I think it was 2020, around the POPI Act. So an argument, but that wasn't there wasn't any consensus, or as in the finalization on that webinar regarding the POPI Act around students and staff issuing or giving out their information or personal information to the academic library, meaning like we are the academic library, but for the purpose of stats and also for the registration towards towards our academic library, meaning like we cannot be able to identify a student if we don't get their details. So there was an argument in terms of some people were stating that it is incorrect or it is wrong according to POPI Act to issue or to request the information, the personal information from the users or from the students and the staff. But the other side was saying that how will we be able to know who you are or who the person is if we don't correct that information, if we don't collect that information? So I want to know, what is your take in that argument? I don't want you to give me any sort of definite answer, but I just want to hear your comment, because even on that one, we never had a sort of a consensus or reach any agreement in terms of what is right and what is wrong.
My take will be again about the whole like mandate. When a student or a user wants to come use your facilities as a public or a private library, especially maybe an academy or university sort of context, there's an agreement going on. They pay a registration fee and you offer these services. And in order for you to offer your services and to fulfill your mandate, you need this personal information. Yeah, am I understanding the question correctly? Or that's where my take is. Like, I can't do my job if I don't have this information. But I will only use this information to do my job.
Yes. Thank you so much.
Is daar nog enige vrae of is almal nou tevrede met wat hulle gehoor het en wat hulle nou weet?
I'm not seeing any other questions or hands. But
sorry. Excuse, I'm asking, is there anyone else who would like to ask a question or do something? Carita, I would really like to thank you for your time, your preparation, and the valuable information you gave to us, because we all know about POPI or POPIA, and
who you
because we haven't dealt with it before, and now I'm sure some of us will re-look at your slides, because you have summarized it for us. We don't necessarily have to work through the whole act. And thank you so very much. I'm sure we all have a lot to think about. Maybe some of us will have to talk to our CEOs and make sure what exactly is in place, because not all of the organizations are complying, and maybe it's our responsibility as librarians to talk to our CEOs and say, you know, I haven't seen this manual, and I'm not sure who's the information officer or whatever may be the case, to ensure that we lead our organizations into the right direction. So Carita, once again, thank you so very much. It was very good listening to you.
Thank you very much. I enjoyed it. I'm going to post my email address in the chat box. So you can feel free to please email me if you have any questions or concerns. I really like POPI, so I like helping people. And then I'll email you the presentation. And thank you so much.
Carita, you can email the presentation to me. You do have my email address, and then we can just disseminate it to all the other people.
Not a problem.
Thank you so very much. Okay, members, we just now need to close our meeting. The one important thing to remember is that our next meeting will be on 20 April. Please diarize that. It will be a talk on gamification and how that can assist you to promote your library by using gamification. So all of you who will be available on the 28th of April, please do join the meeting. It will be a Zoom meeting. I hereby would like to thank everyone who joined our session today. I'm sure all of you did get a lot of valuable information, and please use this information. Make sure that you do comply. Make sure in your personal life you know what to do, and everyone who's taking pictures, maybe we should be a bit more careful when we take pictures, and especially posting it on social media. So yeah, Carita, thank you so very much, and thank you to everyone who has joined us. Have a nice day. I now close this meeting.